Our next panel is on the always sleepy topic of crypto and digital assets. I write a newsletter that was supposed to be about securities enforcement. Now it seems like it's a crypto newsletter because that's all that seems to happen. But this should be a great topic and certainly a timely topic. Let me start by introducing Abe Chernin, who's a vice president at Cornerstone Research based in Chicago, where he co-heads the firm's fintech, blockchain, and cryptocurrency group. Abe has extensive experience helping clients with blockchain forensic data analysis, assessing claims related to cryptocurrency markets, and evaluating the underlying drivers of value for both fungible and non-fungible crypto tokens. Welcome, Abe. I'm very pleased to welcome Jackie Kasulis. She's a partner at Kirkland and Ellis, is in from New York. She's a former federal prosecutor and most recently served as the acting U.S. attorney for the Eastern District of New York. Welcome, Jackie.
Thank you.
Next to her is Katherine Kirkpatrick Boss, Chief Legal Officer of Cboe Digital in Chicago. Prior to joining Cboe Digital, Katherine was General Counsel of Maple Finance, and before that was a partner at King & Spalding. Welcome, Katherine. Next is Lara Mehraban. She is a partner at Sidley Austin in New York. She joined Sidley in 2022 after serving 15 years at the SEC, most recently as the acting director of the New York Regional Office. Great to have you with us, Lara.
Thank you.
She's our moderator today. And finally, very pleased to welcome Kristin Pauley, and she's an assistant director in the SEC's Division of Enforcement in Chicago. And most notably for this panel, she's a member of the SEC's Crypto Assets and Cyber Unit. Welcome, Kristin. Lara, let me turn over to you.
Thanks so much, Bruce, and welcome everyone. I'm excited to be here with this distinguished panel. So I thought I'd start by sort of setting the stage for the panel by talking about the question that's sort of the center of everything. When is a digital asset a security? That's a pivotal issue to all of these topics. So for those of you who aren't very familiar with this area of the law, I'm going to give sort of a high-level overview. Under Section 5 of the Securities Act, an issuer must register the offer and sales of securities unless there's a valid exemption from registration. So in other words, an issuer of securities violates Section 5 if that issuer offers or sells securities without registering them or without a valid exemption from registration. And the definition of what's a security under the federal securities laws is extremely broad. And courts have consistently held that it's a flexible standard, taking into account substance over form. And the definition of a security expressly includes investment contracts. And for purposes of this panel, that is the key term. The SEC and most courts have applied the test for whether something's an investment contract to digital assets in their analysis of whether the digital asset transaction is a security. And that test, as many of you are aware, was set in a Supreme Court case, SEC versus Howe. So in Howe, the test is set out, which states that a contract, scheme, or transaction is an investment contract and therefore a security if there's an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. So way back in 2017, after the issuance of the Dow report of investigation, the SEC started bringing cases charging issuers of digital asset securities, alleging that the issuers violated Section 5 for offering and selling digital asset securities without registering them or without a valid exemption from registration. And the courts in general have found that these digital asset transactions were securities transactions, for example, Telegram, Kit Digital, and many others. But in December of 2022, the SEC charged Ripple and two of its executives, alleging that they sold the XRP token in violation of Section 5. In other words, the SEC alleged that Ripple and its executives sold XRP without registration and without a valid exemption from registration. And since that time, the parties have engaged in extensive briefing and discovery on the issue, and they both filed motions for summary judgment. And in July of this year, Judge Torres in the Southern District issued a mixed decision on the summary judgment motion, determining that certain sales of XRP were securities transactions and other sales were not securities transactions. According to Judge Torres, there were 3 categories of sales: institutional sales, programmatic sales, and other distributions of XRP as payment for employees and services. So on the institutional sales, these were sales by Ripple of XRP to institutional investors. And Judge Torres concluded, applying Howe, that these were securities transactions because there was an investment of money in a common enterprise, and because a reasonable institutional investor would understand that Ripple would use the capital it received from XRP to develop the ledger and thereby increase the value of the XRP token. Therefore, the institutional sales were securities transactions. The other 2 categories of sales, however, Judge Torres concluded were not securities transactions. The programmatic sales were sales on third-party exchanges, and Judge Torres concluded that these were not securities transactions because the sales were blind bid-ask transactions, and therefore the purchaser did not know who they were purchasing the securities from. Therefore, the purchaser had no expectation of profit from Ripple or its executives. And finally, the third category, there were instances where Ripple used XRP as a form of payment for its employees and for third-party service providers. For that category, Judge Torres concluded that there was no investment of money and therefore not a securities transaction. So shortly after Judge Torres's decision, Judge Rakoff, who's also in the Southern District of New York, issued a decision on a motion to dismiss in the Terraforma Labs matter, where he expressly declined to follow Judge Torres's reasoning. Judge Rakoff explained that the Howe test makes no distinction for purchasers of a security, and instead you need to look at whether a reasonable individual would objectively view the defendant's actions and statements as evidence of a promise of profits based on their efforts. So the SEC has requested interlocutory appeal of the programmatic and other distributions holdings in Ripple, and the parties just finished briefing that motion. So very much the state of play on this question is up in the air. And with that, I'm going to turn first to Kristin. I know you can't talk about the Ripple pending litigation, but can you tell us how the SEC thinks about digital assets and some of the recent cases that the SEC has brought that sort of can shed light on this issue?
Sure. I first need to give our standard SEC disclaimer, which you've probably already heard multiple times this morning. But I'm here today in my personal capacity, and any views that I express are my own and do not necessarily reflect the views of the Commission, the commissioners, or other members of the SEC staff. The SEC disclaims responsibility for any statement of any SEC employee. So to answer your question, Lara, so whenever we begin an investigation, whether it's of a crypto issuer or a platform, the threshold question, regardless of whether it's a registration case or a case involving manipulative trading or some other form of fraud, is whether the assets that are being offered or facilitated are securities. So Lara already mentioned the Howe test, which sets forth how we determine whether something is considered to be an investment contract. So I'll just say it again because it's so important in this space. But it's an investment of money in a common enterprise where there's a reasonable expectation of profit derived from the managerial efforts of others. As Lara said, it is meant to be a flexible rather than a static test, and it was designed to stand the test of time, and it's been applied to in many different settings to many different types of products over time. I'll also just mention the Reeves test. So the Reeves test sets forth factors to determine whether a product meets the family resemblance test and is therefore a note, which is also a security under the federal securities laws. So the Reeves test, we look to see what the motivations were for entering into the transaction. We look to see what the plan of distribution was. Was it distributed to a broad segment of the public or to a small segment? What were the expectations of the investors or the participants? And whether there's another regulatory scheme that may govern. So for example, how ERISA governs pension plans, rendering the securities laws unnecessary. So using Howe and Reeves as our guiding precedent, and as Chair Gensler has noted on many, many occasions, we have found that the vast majority of crypto assets appear to be offered in securities transactions. And so therefore, if they're available to US investors, they are required to comply with the US securities laws. Right now, in our view, the market has been rife with non-compliance, which not only puts investors at risk, but it puts at risk the public's trust in our capital markets. And nothing has exemplified this more than what we've seen in the past 18 months with the $40 billion collapse of Terra, the collapse of FTX, and numerous bankruptcies, Celsius, Voyager, BlockFi, just to name a few. So to date, the commission has brought or settled more than 100 cases involving crypto intermediaries and token issuers, covering a broad spectrum of conduct. So there have been fraud cases such as FTX. There have been non-fraud but registration violation cases such as Ripple. We've brought cases involving platforms or intermediaries, such as several cases we brought earlier this year, Beaxy, Bittrex, Binance, and the Coinbase matters. We've brought cases involving touting violations where promoters are touting a particular project without disclosing that they're being compensated. So such as, for example, cases against Kim Kardashian and the Tronix case earlier this spring. Cases against so-called DeFi platforms and services. So for example, the DeFi money market case, and cases involving illegal and manipulative trading, such as a case against Abraham Eisenberg earlier this year, and an insider trading case called Wahi. So the staff has issued guidance to help industry participants determine how Howe and Reeves might apply to a particular product or service. But we highly encourage market participants to consult with experienced securities counsel and to proactively engage with the commission staff before launching a particular crypto asset or service that might implicate the federal securities laws.
Thanks, Kristin. So Abe, you bring a slightly different perspective to this question. Can you tell us how you think about this issue?
Sure. So I am not an attorney, so I'm not qualified to comment on whether a specific asset satisfies the various prongs of the Howey test. I'll leave that question to the lawyers and the regulators. That said, we've, as economists, often been asked to comment on the underlying economics of a digital asset. So that economic analysis can then help inform the facts and circumstances that frame the ultimate Howey test discussion. And on a personal note, these issues have been really exciting for economists to noodle on. We're looking at a new asset class. The underlying economic questions that have followed are actually pretty novel and new. So to oversimplify a bit, I'm going to highlight two high-level economic questions that I think can help inform a legal analysis of the Howey test prongs. And the specific Howey test prongs I'm talking about are whether there is an expectation of profit that is derived from the efforts of others. And a less formal disclaimer, this is just my own opinion. It's definitely not settled canon. All of this is, as you're going to hear, playing out in courts, the developing regulatory framework, and the economic literature still is in its infancy. So reasonable minds on this stuff can definitely differ. That said, to help get at whether the purchaser is relying on the efforts of others, the first economic question that I typically think about is, empirically, what is driving the value of the asset? Otherwise stated, what's actually moving the prices? Is it actions from active participants who are providing managerial efforts, things like promotion and distribution, market making, or various business decisions that managers are making? Or does value come from a change in expectations about the overall adoption of digital assets? This would include industry-wide events and news. Or is value simply driven by randomness? Sometimes it can seem so to an outside observer. Or does value come from users' expectations about widespread adoption of the network and the overall health of the underlying protocol of the digital asset? So this question of what is actually driving the value of the asset sounds like a pretty simple question, but in reality it can be quite complicated, and it's been a heavily debated topic all the way going back to the ICO wave and the Dow report back in 2017. So an economist can add value to this question, this what is driving value debate, by applying sort of tried and true methods like factor analyses and event studies to these questions. What tools like an event study does is to attempt to isolate the impact of individual events from other potential confounding factors that contribute to price movements. Tools like this enable us to look at the impact on asset value of specific tweets, or volatility in the Bitcoin market or other digital assets, lawsuits, or frankly news stories about China banning crypto transactions and things of that nature. So in general, thinking about what is driving the value of the asset can help a fact finder evaluate whether the asset is operating in a decentralized environment and or whether the value of the asset depends on the efforts of others. Quickly, the second question, to get at the question of whether an owner has a reasonable expectation of profit, there's one question that I've been asked over and over again, and that is, what does the data show about how owners of the asset actually use it? Is the asset typically being used for consumption, or do buyers buy for speculation or profit? In my mind, this is a pretty relevant question, even if there exists a secondary market or platform for a given asset. Because it's one thing to note the existence or promotion of a secondary market, but actual consumer behavior, I found, is pretty illuminating. And what you can do is you can apply traditional consumer behavior economic theory to the data. Typically, this happens via some sort of blockchain tracing analysis. And we can look at the features of the asset itself, but also what users are doing with the asset upon purchase. And this idea of use versus speculation is going to be really relevant for the emerging NFT issues that I think are now starting to emerge. So I think from an economist perspective, these are really exciting questions that feed into the Howe test, and not just because they're unsettled and the subject of rigorous debate, but also because these assets exist in such a data-rich environment. So people like me can really roll up our sleeves and start thinking pretty deeply. So I'll pass that back to you.
Thanks, Abe. Catherine, you offer even a different perspective as an in-house crypto exchange GC. Can you tell us sort of how you think through the question of digital assets as securities or not?
Yes, it's been a busy stretch as a crypto GC. Understatement of the century. I think a couple things to note that's very interesting about this landscape. One, it's important to distinguish between crypto entities and crypto exchanges. For example, Cboe Digital, which is effectively the crypto subsidiary of Cboe Global Markets, we are a fully regulated DCM and DCO for futures by the CFTC, and then we also have a spot market listing 5 digital assets, only 5, by design, that is licensed by the states as a money transmitter and New York as a bit licensee, et cetera. And we are a fully intermediated we have a fully intermediated model, which differs materially from a lot of the other crypto incumbent exchanges. You know, our goal is to look and feel a lot like traditional market structure. A lot of other crypto native exchanges are taking a different approach. So the landscape is quite difficult for compliance first entities like Cboe Digital. And there is some sense in the market right now that some of the entities that are proactively communicating and attempting to work collaboratively with the regulators are in turn losing market share to those who are taking a different approach. Now, we don't have any hesitation surrounding that approach. That's our culture. We prioritize above all else our good and long history of collaborative relationship with our regulators, Cboe Digital's regulator, CFTC, but also Cboe Global Markets regulators, the SEC. But from the kind of crypto CLO perspective, I think there's a couple things to consider. One, I always joke that being a crypto lawyer makes you a more important lawyer than a lot of other industries. The business really pays attention to me above all else. So I think understanding the regulatory developments, trying to see what's going on through litigation, through pending legislation, through rulemaking, through settlements, and remaining educated about all of the facets that may or may not affect us, not just exchanges and clearinghouses, but also on a macro level, what that could mean for institutional flow and institutional engagement, and advising the business accordingly on that strategy, and also assessing risk. You know, we list 5 tokens. One of those is Bitcoin. We feel very good about Bitcoin. The other 4, it's quite confusing in some ways to be a lawyer in this space because we also have an environment where the CFTC has explicitly named certain tokens as commodities, thereby disagreeing with the SEC. So as a market participant who is really trying to strive for a low-risk environment and proceed business as usual and potentially list new products to grow the business, you're really kind of taking advice from a bunch of different sources right now. So I think we're doing the best we can, and I think I am above all else absolutely in favor of the commission enforcing against the wrongdoing in the space. You're seeing a lot of fraud truly wrapped up in crypto, and that is just giving all of the industry a bad name. So we are absolutely supportive of that. I do hope for a future where there's a more collaborative, friendlier relationship right now between crypto as an ecosystem and the commission.
Thank you, and that's a perfect segue, Jacqueline, to you. When you were at EDNY, you were involved in a number of the very early litigations and cases against fraud in the crypto space. Can you talk about sort of the difference between actions involving allegations of fraud and the regulatory violations?
Sure, yeah, I'm happy to. So I was at the DOJ for almost 13 years, and when I was the chief of the Business and Securities Fraud section, I actually worked really closely with Lara and her team on these first cases. And so the first case that we brought, which is I think one of the first cases in the country, is a case that is commonly referred to as Recoin. The defendant's name is Zevslovsky, so everyone just defaulted to Recoin. But that case was brought in 2018, and when I was prepping for this panel, I was so surprised that it was actually that recent, because it feels like it was decades ago. So much has happened since that point in time. But we worked very closely with the SEC on that matter, and we got a very good decision from our judge in which the judge found that securities laws could apply to fraud in relation to cryptocurrencies, virtual currencies, and specifically their initial coin offerings or ICOs. And so this was one of the sort of first decisions upon which a lot of these fraud cases have been built, and obviously we've seen a number of those since that time. So with respect to the prosecution of fraud, I do think that DOJ does have it easier than the SEC and the CFTC, because the criminal statutory framework is simpler in that there are statutes that DOJ can use that are not reliant on whether the asset or the object of the fraud is a security or is a commodity, right? There's securities fraud and there's commodities fraud, but there's also wire fraud, which is just the fallback position that you see the DOJ take over and over and over again. So if you look closely at these fraud indictments, what you'll see is when it's pretty clear, according to the law and the general consensus, it's a security, you'll see securities fraud charges. Same thing with commodities fraud. But always the backup is wire fraud, because again, you don't need to have a security or a commodity there. It just needs to be, money or property that's the object of the conspiracy. So, and then if there's real uncertainty, just generally speaking, like is an NFT a security, what you'll see is the DOJ will just charge wire fraud. So the OpenSea NFT case, the Wahi case with Coinbase, those were just straight wire fraud cases, even though they were touted as the first insider trading cases, right, in this space, but they were actually not charged with securities fraud or commodities fraud. So again, the DOJ can kind of take a more sort of sidelines approach here because it has the tools that it needs to prosecute fraud. And going back to your point, what the DOJ is leaning into are matters that I think just objectively speaking, everyone just believes is truly bad conduct, right? It doesn't sort of depend who you are in the industry or in the general public. It's just, that's bad, and people need to do something about that, and someone needs to go to jail, right? Mm-hmm. So the DOJ just, in terms of what they are focused on and what their mandate is and the tools they have, it's easier to navigate in this space. But when you really then move more towards the regulatory sort of violation framework, that's where things become much more controversial. Businesses, obviously, they want to be good corporate actors, but there is just a lot of uncertainty, right, around these regulations, and it costs a lot of money to be compliant, and you have to be a little bit, less, more sort of risk avoidant if you truly are subject to these violations. So it's not just as easy as saying, well, everything's a security, so just comply with everything. Like, I don't understand what the problem is. It's just much more complicated than that. So I do think that DOJ has a little bit of an easier go of it right now because they just don't have to engage as much in these issues.
Yeah, good points. I'm going to narrow down the topic slightly and focus on exchanges, crypto lending, NFTs, the title of the title of our panel. Kristin, can you tell me sort of how the SEC is thinking about those 3 areas and some recent cases, particularly in the NFT space, which the SEC brought 2 cases very recently on?
Yeah, I'll start with NFTs. So as Lara just noted, in the past few weeks, we actually brought our first cases concerning NFTs. In both cases, the companies were charged with conducting unregistered offerings of crypto asset securities in the form of NFTs, or purported NFTs, I should say. The first company was called Impact Theory. It was an LA-based media and entertainment company. They offered and sold 3 separate tiers of NFTs. They were called Founders Keys and raised approximately $30 million from hundreds of investors. The second one was the Stoner Cats case. They raised, I think it was $8 million in just 35 minutes. And the money was used to finance an animated web series called Stoner Cats. You were only going to be able to watch the series if you owned an NFT. In both cases, the SEC found that the marketing campaigns led investors to expect profits. So for example, Impact Theory told investors that they were trying to build the next Disney, and that if they were successful, it was going to deliver tremendous value for the investors. Stoner Cats, the people behind it, touted their expertise as Hollywood producers, well-known actors. They touted their knowledge of crypto asset projects, and they told investors that the more successful the show, the more successful your NFT will be. Both cases involved a royalty, so for all resale on secondary platforms, the companies or the promoters would get a percentage of that. So in both cases, they settled with the SEC without admitting or denying the SEC's findings. They agreed to a cease and desist order, which, among other things, found that they had violated Section 5 of the Securities Act. They agreed to pay certain amounts of monetary relief. The Stoner Cats agreed to destroy the NFTs, and Impact Theory agreed to destroy the tokens that were linked to the artwork with the blockchain entry, not the artwork itself. They also agreed to eliminate the royalty components. So these cases, I think, really drive home the point that the SEC were required to look beyond what something is called or labeled. So instead, we're going to focus on how the product or service was marketed, whether they were touting its potential success would drive or bring profits to the investors. We're also going to look at the economic realities of the transactions. So for example, if you're telling investors that they can expect a profit based on your efforts, that looks a lot more like a securities transaction from our perspective. I'll just say a couple quick things about so crypto asset intermediaries has also been another area of focus. So whether a platform calls itself centralized or decentralized, they often provide a suite of services that are typically separated from each other in the traditional securities markets. So exchange, matching settlement functions, custodial clearing functions, broker-dealer functions, lending functions. And this commingling, we have found, creates a lot of conflicts of interest. It raises risks for investors. And so, as I mentioned before, we brought some cases in this space recently, the Beaksy and Bittrex matters, as well as the Binance and Coinbase matters, which are in litigation. Crypto lending products has also been another area of focus. So this is another type of public offering. It goes by different names sometimes, but it generally is offering the opportunity to earn yield or interest. These projects have raised similar concerns for us of fraud, registration violations. They also could raise potential violations of the Investment Advisors Act, the Investment Company Act. So a few examples in this area are the recent Linus financial case that we brought a couple weeks ago, Celsius, Genesis, Gemini. I could go on and on, but those are just a few examples.
But just to take us back to Stoner Cats, if you haven't Googled Stoner Cats yet, I would definitely recommend doing so just for entertainment value. So Katherine, you want to talk a little bit about crypto lending and some developments in that space?
Yeah, what's really interesting to me about crypto lending is at the height of the last bear market in crypto, that was a $20 billion market. And it effectively overnight, through the many cases that we could mention in 2022, evaporated. And I raised this because it was very interesting to me as of, I think, a week or two, Coinbase quietly filed a Form D. And I'll also note, I've observed a lot of crypto companies are using kind of Reg S, Reg D to try to bypass this issue entirely. Seemingly not all of them are using this correctly. I'm a bit of a broken record on the fact that you have to file the Form D to get the full exemption, but they're trying. And so they are recently, they've raised about $57 million in terms of crypto lending. And I note that because I observed that with interest to see whether that activity was going to resume. It's going to be far more difficult to engage with crypto lending given what occurred in 2022, in large part due to really reprehensible risk infrastructure, lack of legal and compliance infrastructure. There were a lot of learnings, I think, in and out of crypto from the events of 2022. But that being said, you can't just have 20 billion evaporate without any sort of replacement. So there's clearly an institutional eye on engagement with crypto lending. I'd be very interested to see what emerges from the ashes and whether that's done appropriately and correctly. And on that note, I also observed something of interest just a few weeks ago. There was some Second Circuit precedent confirming the fact that the syndicated loan market was not, in fact, note securities based on the Reeves test. So a lot of crypto was watching that with interest, given the fact that that decision, if it had gone the other way, could have been potentially very negatively impactful for on-chain lending generally. So a lot going on in that space. We're not involved, but me intellectually, again, watching kind of the macro effects on the market of that, watching that space.
So Abe, I'm going to turn to you next. Kristin mentioned a lot of cases that the SEC has brought. Can you talk a little bit about what happens to the value of the tokens themselves when the SEC brings a case or when there is a regulatory event?
Sure, and I am also interested to see what arises from the ashes of crypto lending. It's an interesting one. But going back to the question, so I actually looked at 2 test cases for this type of thought experiment. You heard about Bittrex, which is SEC brought a case against a U.S. exchange, and then there was an insider trading case brought against an ex-product manager at Coinbase, which is what we're calling the Wahi case. And those cases are useful for this type of exercise because the complaints specifically listed 6 and 9 tokens that they believed to be securities that were being sold through these exchanges and et cetera. And 6 and 9 tokens is a good number because there are not so many at issue that it's challenging to disaggregate any price movement of those tokens from the overall cryptocurrency market. So looking at these 2 cases as proxies, there's a finding that is perhaps less than intuitive. We do not observe lasting negative token-specific price movements immediately after these suits are filed against platforms. These big public lawsuits against platforms can and often do affect crypto prices market-wide. These are because of concerns about adoption of the technology, fears of increased regulatory scrutiny across the industry, et cetera. But it is really hard to identify an immediate negative impact on individual token prices when they're named in a lawsuit against some sort of platform. So it may be counterintuitive to some. It's actually not that surprising to me because we've noticed over the years that in general, token prices are very highly correlated with one another, even when there's a big token-specific news event. We've seen crypto token prices move the most on days when events occur around general demand and adoption of the technology. For example, the day that China banned crypto transactions, the whole market tanked. And on those days, everything moves together at once. So we have seen across a large cross-section of tokens, not just the 6 and 9 in these particular litigations, that the days when a token's returns are significantly different than the market, it's generally divorced from the news of the token issuer itself, but rather because of the health and the strength of the underlying protocol. So what might explain this? Why is this the case? First, with traditional equities, the factors that drive prices tend to be a company's profits, growth, and just general overall financial health. So in this equities world we're all used to, one would expect adverse company news like a lawsuit to move prices downwards, and then positive news would move those prices upwards. However, with many tokens, with goals, of a robust decentralized network of users. There are factors that are outside of traditional financial metrics that can indicate the overall health and strength of the protocol. So with tokens, issues like network addresses, number of nodes, scalability and adoption of the network are things that actually matter a lot and have outsized importance in this world. And so those things are not necessarily an issue when the tokens are identified in a suit like SEC versus Bittrex. Secondly, quickly, with traditional U.S. equities, if you want to buy, for example, Apple stock, you got to go to NASDAQ, right? There's pretty much one big player in town. So any lawsuit against NASDAQ which puts the ability to sell Apple stock at risk may have a significant impact on Apple's liquidity and ultimately its value. With digital assets, it's a bit different, right? If you want to buy a token that's named in the Bittrex lawsuit, a potential buyer could just purchase that token on a different non-US based exchange. So any potential price impact resulting from liquidity concerns just isn't present in these types of cases. So again, surprisingly, a token gets named in a big lawsuit against a platform, not a lot of price movement. So I thought that was interesting to mention.
That is really interesting.
One other thing to note on the token environment that I've observed, it's very interesting. We've obviously had a multitude of SEC lawsuits levied against exchanges. The diversity of tokens named in these exchanges is notable. You have a wide swatch of different kinds of tokens that exist. And in all of these lawsuits, which I assume is by design, you're seeing metaverse tokens, decentralized finance tokens, altcoins. You're seeing a wide swatch of tokens with different look and feel and characteristics, which I actually think is quite strategic by the commission, because if they lose on one token, if they ultimately lose on appeal in XRP, they can go and distinguish and have kept consistent all along that it's a facts and circumstances-based analysis. So you want all of these radically different tokens, and the things that I always tell people is you're not necessarily seeing the most centralized tokens in these lawsuits. You're not seeing the tokens that look and feel the most like a security. In fact, some of them are quite decentralized. So I think that that's a particularly interesting note about the diversity of tokens at issue in litigation right now.
Yeah, that's a good point. And also, I assume there's an exception for if the SEC or the DOJ alleges that the token was fraudulently offered.
Yes,
Right.
yes. So I'm talking about exchanges like against the platforms themselves.
Right.
Yeah. So Jackie, I'm going to turn to you. There have been a lot of notable bankruptcies in this area. Kristin mentioned a few of them. Can you tell us a little bit about the kinds of issues that come up in the bankruptcy context for these assets?
Sure. So, obviously there was a domino effect that occurred from the collapse of Luna, Terra USD, obviously the FTX collapse. And so what came with that was sort of a run on the bank sort of situation and liquidity crunches, and then everyone is filing for bankruptcy. And so I think what we've also seen in some instances is where the SEC does bring sort of a fraud or regulatory violations against a platform, that can create so much uncertainty around that business that then it actually drives that business into bankruptcy, which has been a criticism as well, right, in this space. So lots of bankruptcies going on, and the complexity of it is also that they're all interrelated, right? A lot of their assets are all at these different platforms that have all declared bankruptcy, so it becomes a very complicated situation, becomes even that much more complicated. So a number of issues there. The first is that, the DOJ and the SEC and oftentimes the CFTC are doing their own investigations, right, into the conduct, because all of this has come from this sort of base, set of facts, this core conduct that everyone is very interested in, right? So DOJ, SEC, CFTC, they're doing their investigations. Then separately, as part of the bankruptcy, you have all your interested parties who also need to do, their own investigations, and the company itself needs to do an investigation even to be able to testify in support of releases, for example, for D&Os. And so it becomes very, very complicated to actually get at the crux of sort of what the issue was and who did what when, because you have so many people trying to investigate the same set of facts. I think separately, you get back to this issue of which assets are securities, right? It sort of gets teed up all over again because you're trying to define what the assets are, what the value of the assets are, and the claims, right? that exists. So the SEC oftentimes will, have its own claim. Well, what is the value of that claim? Well, it goes back to what's a security, right? What are securities on the platform? We've also seen instances where the SEC actually will object in these bankruptcy contexts. And so there was an instance where Voyager Digital was trying to sell about $1 billion in assets to Binance, and the SEC actually objected to that sale and said there wasn't enough detail around it to determine, whether or not there was enough security around the assets and things along those lines. Again, sort of in the interests of protecting investors, and ultimately the bankruptcy judge did allow that agreement to go forward, but then Binance canceled it, saying that the reason that they decided to terminate it was because of regulatory uncertainty. So, you have sort of that overlay. And then on top of it, the DOJ, because they've brought all these criminal actions, are also making all of these sort of forfeiture claims, right? So they're freezing all of these assets on these different platforms. And, so BlockFi, for example, is trying to get assets back from FTX. DOJ is saying, no, we've frozen those assets because they're, proceeds of illegal conduct. And then the question is, we're like, well, who gets those assets, right? Should the DOJ get it? What about the victims, right? Who are the users or the account holders? Like, who gets that money? How do you figure that all out? So it just makes an already complicated situation, exponentially more complicated when you're dealing with all these interrelated bankruptcies.
One thing to note is I think crypto is breaking the mold in a multitude of ways. A couple observations that I've noted is 5 years ago, when I was in private practice and white collar, obviously your whole goal often is to handle something pre-disclosure, so it never, no one ever knows about it, not only because of the negative effects to the company, but also on the broader market. This could eliminate the potential of this partnership and this deal and this engagement. No one's going to want to engage with us if we're being sued by the SEC. Well, it doesn't seem like anyone is afraid to engage with Coinbase right now. And that's truly unprecedented, the degree of institutional, traditional financial services, or TradFi, as us crypto folks call it, engagement with an entity that is currently being sued by a regulator. It's kind of stunning. It's truly broken the mold. And part of that, I think there is some sense that this is being seen as somewhat of an intellectual fight, in direct contrast to, for example, other actions like the Binance suit, which is viewed very differently. And then there's also a sense within the crypto market of what are we going to do about this if we have securities, like tokens that are securities, tokens that are non-securities, like Bitcoin, tokens that are potentially registered securities, because some tokens have announced publicly that they're seeking registration. I'm sure we're going to see that in a few years. And then tokens that are maybe unregistered securities, maybe commodities, maybe none of the above. How does an exchange, for example, grapple with listing all of those entities together? So I look forward to finding a solution on a go-forward basis, but there's a trickle-down effect from those questions that affect everything from restructuring to market prices to institutional engagement, which we continue to see a significant appetite in M&A activity, investment activity, exploration beyond tokens and exchanges. For example, the tokenization of real-world assets, that's kind of the hot topic as of now. Tokenizing securities, what does that mean from the regulatory perspective? Tokenized commodities like gold, tokenized ETFs, that's something we're all going to have to discover intellectually in the next few years.
So with all of that uncertainty, Katherine, what advice would you give to an in-house GC dealing with some of these issues?
Good question. The only thing I'll note is I think the crypto general counsel world is quite collaborative and supportive. There's many crypto lawyers that are genuinely trying to do the right thing. I value my relationship and working collaboratively and having intellectual discussions with the regulators. I hope, again, that the relationship improves. I think that there's a sense of let's look to the law, let's look to the precedent. We look forward to having more law and more precedent to dig from. I think that many of us wish that a lot of these projects would litigate these cases because that would be more informative to the broader community. Unfortunately, we're also dealing with a situation where a lot of crypto entities are severely undercapitalized right now, given the environment, and they don't have the ability or the appetite to litigate. That's just the reality of this situation, and obviously I, for one, am paying very close attention to SEC settlements. I do think that they are educational. there is some sense of disagreement there. But I guess my advice would be, it's certainly a fun space to be in. It's certainly a quite exhausting space to be in.
That is good advice. All right, we have just over a minute left. So Kristin, I'll end with you. Can you talk a little bit about how the SEC deals with the foreign regulatory aspect of these cases?
Sure. So, one challenge that we often face in many of our investigations is that the crypto firms or, firms affiliated with these crypto projects can be non-cooperative, and they can claim overseas jurisdiction, sometimes despite offering products or services to U.S. investors. And so in those instances, we will work with our internal Office of International Affairs and through numerous multilateral MOUs that we have with different jurisdictions to either obtain evidence from abroad or to serve a defendant who resides overseas. So probably the main one is the IASCO, the International Organization of Securities Commissions MOU that we have. So the SEC, and there's approximately, I think, 120 foreign securities and derivatives regulators that are signatories to that MMOU. And it commits the signatories to exchanging information, to permitting the use of that information in civil and administrative proceedings, to allowing us to share that information with various SROs and our criminal partners, and to maintaining the confidentiality of that information. I'll just note that we do have a few additional MOUs with particular jurisdictions that go beyond the IASCO. So for example, with Germany and Australia and Hong Kong, we're allowed to take investigative testimony pursuant to these MMOUs. So generally speaking, though, jurisdictions are encouraged to supply information to other requesting jurisdictions to the extent that it doesn't violate their own laws. And the only other thing I'll just note on this topic is that many securities regulators across the globe look to the United States for guidance and leadership in all facets of the securities laws, and that's definitely been what we've seen in the crypto space as well.
Thanks, Kristin. And thanks everyone on the panel. It was very informative, and thank you, audience, for listening to us.